m'aider
à souhaiter la bienvenue à Madame la juge Obansewin.
Madame la juge Obansewin, membre de la Chambre des communes et du Sénat.
Commons in the Senate, students, and other guests who are here with us in the room today, all Canadians who are listening or watching remotely, I wish you welcome.
On the traditional unceded territory of the Algonquin people for a truly historic event, and we thank you for joining us. Je m'appelle Alain Roussy.
My name is Alain Roussy, and I'm a professor and vice dean of the Common Law in French program at the Law Faculty, Section Common Law at University of Ottawa. And I have the very great honor of acting as moderator today for this exchange between, on the one hand, the Honourable Justice Michelle Obansewin of the Superior Court of Justice of Ontario and nominee for a seat on the Supreme Court of Canada, and on the other hand, members of the House of Commons and Senate specially brought together for this occasion.
The presence of the following individuals: the Minister of Justice and Attorney General of Canada, the Honourable David Lametti, the Chair of the Independent Advisory Board for Supreme Court of Canada Judicial Appointments, the Honourable Wade McLaughlin, the National Chief of the Assembly of First Nations, Ms. Roseanne Archibald, the President of the Métis National Council, Ms. Cassidy Caron, the Deputy Minister of Justice and Deputy Attorney General of Canada, Mr. François Daigle, and the Commissioner for Federal Judicial Affairs, Monsieur Marc Giroux. La nomination d'une juge à la Cour.
The appointment of a judge to the Supreme Court of Canada is a very important event in our constitutional democracy. This court of last resort is not only called upon to deal with litigation on national interest questions, but also to deal with and keep the balance on constitutional issues between various levels of government, not to mention, of course, the Charter of Rights and Freedoms in Canada. Respected throughout the world, our Supreme Court is recognized for its independence and the excellence of its bench.
That rests upon the shoulders of the judges of the Supreme Court of Canada. It is crucial that a rigorous process be followed when the time comes to select a new member of that court. In this case, the process was launched by the Prime Minister of Canada on April 4th of this year in light of the upcoming retirement of Justice Michael Moldaver. Justice Moldaver was appointed to the Supreme Court of Canada from the Court of Appeal for Ontario. In recognition of the Convention of Regional Representation, the process to select a replacement was open to candidates from the province of Ontario. Since 2016, this process involves the creation of an independent, nonpartisan advisory board whose mandate is to provide a short list of candidates to the Prime Minister for Supreme Court appointments. Cette année, le comité consultatif.
This year, the Independent Advisory Board for Supreme Court of Canada Judicial Appointments was presided by the Honourable Wade McLaughlin, former Premier of Prince Edward Island, and was made up of the following members: Paulette Cyr, Conrad Siri, Charlene Theodore, Jacqueline Horvat, the Honourable Louis Charon, Richard Jockelson, and David Nawegabo.
The Advisory Board conducted an evaluation of the candidacies based on the criteria released by the Prime Minister. This long list of criteria includes a superior knowledge of the law, superior analytical skills, the ability to resolve complex legal problems, an awareness of and ability to synthesize information about the social context in which legal disputes arise, clarity of thought, an ability to work under significant time pressures in any area of law, a commitment to public service, irreproachable integrity, respect for others, an ability to appreciate a diversity of views, perspectives, and life experiences, moral courage, discretion, and an open mind. Le gouvernement s'est aussi engagé.
The government also committed to appointing justices to the Supreme Court only if they were functionally bilingual. Finally, the government committed to ensuring a reasonable balance between the expertise of justices in public law and private law, ensuring that this expertise flowed over a whole gamut of questions brought to the Supreme Court, and also that they would reflect Canadian diversity in a reasonable way.
Applications that were received. The Advisory Committee provided the Prime Minister with a short list of eligible candidates. On August 19th of this year, Prime Minister Justin Trudeau announced the proposed appointment of the Honourable Madam Justice Michelle O'Bonsawin to the Supreme Court of Canada. She currently serves as a judge of Ontario's Superior Court of Justice. She is an Abenaki member of the Odanak First Nation, making this a truly historic moment for Canada and for Indigenous peoples of Canada in particular. Elle est aussi franco-ontarienne.
She is also a Franco-Ontarian, and this is an extremely meaningful moment for Francophone Ontarians and for Francophones in Northern Ontario in particular. She has 2 diplomas from the Faculty of Law of the University of Ottawa, and it is a moment of great pride for our department. Madam Justice O'Bonsawin, congratulations.
Lors d'une audience spéciale.
During a special hearing that was held earlier this morning, the Minister of Justice and the President of the Advisory Board appeared before the Standing Committee on Justice of the House of Commons to discuss the process, the selection process, and the grounds on which she was selected. The process provides for a public forum for exchange between the nominee and the public and parliamentarians, and that is why we are here today. The purpose of our exercise is to say to all those who are listening to us today or who are with us today that this is your opportunity to get to know the nominee and to get to know what her experience has been and what has led her to this point.
To be conducted in the highest tradition of civility, respect, and restraint, being mindful of the primary importance of the principles of judicial independence and impartiality. While Canadians, through their elected representatives, must be able to participate in democratic decisions, they must also rely on a judiciary that can make decisions that are free of influence and that are based on fact and law. Thus, in the exchange that will follow, parliamentarians are reminded that they should not ask the nominee to comment or take position on issues that may be pending or may arise before the Supreme Court, such that the nominee could be perceived as having prejudged such issues. While it is perfectly acceptable to question the nominee on her responses to the candidate questionnaire, on her understanding of the judicial role or the act of judging, or on how she views the Supreme Court's relationship to the other branches of government, parliamentarians should refrain from questioning the candidate on her interpretation of specific legislation or regulation, or on hypothetical issues that could be debated before the court. They should not ask the nominee to comment on previous decisions of the Supreme Court, or indeed to comment on or to justify her own past decisions. Likewise, the candidate should not be asked to comment on the nomination process itself. It is my role to make sure that such rules are respected. En bref, les parlementaires de
So, in a word, parliamentarians should seize this opportunity to have an exchange with the candidate, with the nominee in the role that is being proposed for her to be elevated to the Supreme Court. It is possible that I may have to intervene in the discussion or ask someone to reformulate their question to preserve judicial principles. I thank you in advance for your cooperation with respect to this.
Take place as follows. Justice Obansuwin will first make an opening statement of approximately 15 minutes. Then I will invite the members of the House and of the Senate to ask questions following the order which they have all agreed upon. I should mention that this is not a regular meeting of the House of Commons or Senate standing committees, and as such, parliamentary privilege does not apply to this special hearing. Parliamentarians will each have a maximum of 5 minutes to engage into a discussion with Justice Obansuwin. To be sure, those 5 minutes include the question or questions and the answer or answers. I will be responsible for keeping the time, but I am sure that I can count on each and every one of you to assist me in the discharge of that duty. Une fois les parlementaires entendus,
once the parliamentarians have been heard, there will be a short closure speech, and we will end by 4:30. I now have the very great pleasure of introducing the Honourable Madam Justice Michelle Obansuwin, nominee for the Supreme Court of Canada by the Prime Minister of Canada. Madam Obansuwin.
Kwaid Nidobak, Nadeliwizi Miselis Obansuwin, Nodiawi Odanak, Wabanakik and Noba, Ta Plawino Nia. Je me nomme Michelle Obansuwin.
My name is Michelle Obansuwin, and I'm a member of the Odanak First Nation. I am a member of the Abenaki Turtle Clan. Good day, Vice Dean, Senators, Members of
Parliament, Senators, and distinguished guests. C'est un grand honneur pour moi.
It's a very great honor for me to be amongst you today. I have to pinch myself from time to time to ensure that this just isn't a dream. As a little girl, I already wanted to be a lawyer. During my youth, people asked me, what do you want to do later in life? And I always answered, I want to be a lawyer. The law attracted me from a very young age. I grew up in a small Franco-Ontarian village called Hammer near Sudbury. I'm an only child, a daughter of Richard and Diane Obansuwin. My father was a machinist and my mother a teacher. My parents showed me from a very early age that importance of working hard and doing my best, 100%, no matter what the task. And this is what I've always done. As an only child, I was very lucky, though, that my father came from a big family of 8 children, and my cousins, they only lived about 5 minutes from me. So they're like my brothers and sisters, and they still are today. This large family plays a very important part in my life. We spend a lot of good times together as a family, summer vacation, Christmas and holiday seasons. At our family reunions, we always started with smudging, and then we had a call and answer songs, sing-alongs, dances, and we really had a good time together. Growing up as the young member of the First Nations off reserve, my family had to face adversity. And I remember a conversation, a memorable one that I had with my father. He asked me if the other kids laughed at me because I was Indigenous. I said, as I remember, no, they laughed at my name because it was different from the others. My father told me that when he was a little kid, the other kids used to laugh at him and his family, and they called him the little sauvage of Sunnybrook Road. During my childhood, I didn't have the opportunity to really learn my heritage, my Abenaki heritage, because I was living off reserve. However, since my teenage years, the linkage with my family and Odanak has become stronger. I am very aware of my identity, my Indigenous identity, and who I am and who I represent. I decided from school, early school, to follow the path of the law with the support of my family and other persons. However, everybody wasn't in agreement with me. At high school, when it came time to make your choices, your career choices, I was told that maybe law wasn't for a little girl, a francophone who came from Northern Ontario. Maybe it really wasn't for me, but I thought to myself, okay, you just watch me now. I had the support of some teachers, and I want to point them out, in particular, Claire Fournier, who always encouraged me. Madame Fournier, thank you for your support. After high school, I did my BA at Laurentian University in Sudbury, and in '95, I moved to Ottawa to continue my studies in common law in French at the law faculty of the University of Ottawa, where I met my spouse. During my studies, I became more involved in the Indigenous community. For example, I volunteered at the Legal Aid Clinic in the section of Indigenous Services, and I was a member of the Students Association, the Indigenous Students Association.
Minister of the then Department of Indian Affairs and Northern Development. It was an amazing time since it was during the creation of Nunavut. Afterwards, I worked as a law student at the RCMP Legal Services Department. I joined the team as a lawyer after I completed my bar exams. This unit performed a lot of legal work, legal opinion work to be exact, but my plan was to litigate in Indigenous law. I applied at local firms hoping to get a position because this was an area I was very passionate about. But I have to tell you, I was not successful. I later joined the Legal Services Department at Canada Post Corporation. I have to say, I loved my work there. There's a very human side to labor and employment relations. My position allowed me to travel throughout Canada and see the length and breadth of our amazing country. I met people where they lived and worked. My position at Canada Post provided me with a deeper understanding of the links that tie our society together across our country. I was then recruited by the Royal Ottawa Healthcare Group because of my experience in labor law, and I was tasked with creating its legal department. Once I joined the Royal, I realized that there was interesting and stimulating work in mental health law. I was fortunate enough to work with colleagues and professionals who helped me better understand and appreciate the complexity of mental health issues. I was grateful to have been surrounded by a great team, including my assistant, Nicola Tomlinson, who kept me organized, and frankly, at times, she kept the sharks at bay. My work at the Royal has provided me with insight into people who are affected by mental health issues and who are often marginalized. I met daily with psychiatrists, patients, family members, and community stakeholders. With the continuing efforts to increase Canadians' awareness of mental health issues and to destigmatize mental illness, my experience has assisted me as a judge to review all cases with an open mind and sensitivity. Institutions such as the Royal provide vital services to our population, which have become even more important in the last 2.5 years due to the pandemic. Since the Royal is a teaching hospital, I was able to perform research into mental health legal issues. This provided me with a clearer understanding of the nexus between mental health and the law. My specific research was in the area of mental health law and the possible use of Gladue principles in the forensic mental health context. The forensic mental health system deals with unfit and not criminally responsible accused due to mental illness. Gladue principles require sentencing judges to pay particular attention to the background of the Indigenous accused. These principles have also more recently been used in bail hearings. In 2014, I completed my master's in law at Osgoode Hall with a specialty in mental health. During that period, I continued to work full-time as general counsel at the Royal. I was very involved in its initiatives regarding mental health and Indigenous people. The residential school system impacted survivors and their families in a devastating way. I started speaking at conferences about these issues. I was approached to become a member of the University of Ottawa's Board of Governors. My hope was to add an Indigenous voice to that board. I shared my mental health law experience to assist with the emerging issues faced by students and employees and raise concerns facing Indigenous students' access to post-secondary education. In 2016, I decided to pursue my PhD in law at the University of Ottawa. In October of that year, I was encouraged to apply to the Superior Court of Justice, which had always been an ambition of mine. I submitted my application in May, and in May 2017, I was fortunate enough to be selected for the role. By that time, I had completed my PhD mandatory coursework. I took leave from the program for a period of about 2 years in order to focus completely on my role as a judge. I will be honest and tell you that as much as it was exciting joining the bench, it was also quite the adjustment. I'm very fortunate that Justice Charles Hackland took me under his wing. I am confident that he was instrumental in my success on the Superior Court of Justice. I have often said that I have stood on the shoulders of giants, and he is definitely one of them.
Later, I decided to go back and pick up my doctoral program. It was a good thing that I'm a really organized woman. It was useful to me because I had to continue to sit full-time as a judge. Last December, I defended successfully my thesis that dealt with legal psychiatry. And Gladue principles were part of my research. My supervisor, João Veloso, believed in me in my research, even when it wasn't easy. It wasn't easy to achieve that. I recognize that. I had to find a balance between my work as a judge, my doctorate, all the while being the best mother I could for 2 sons and a real partner for my spouse. I hope that I can say, and you will say, that I succeeded. At the Superior Court of Justice, I presided over quite a variety of matters. During the past 2 years, I mainly dealt with criminal matters, matters involving family law and the protection of childhood. My experience in the past was as a litigant, was very helpful in my work in court. I hope to be able to be described as a judge who is well prepared, listens attentively, is sympathetic, and makes judgments that are clear and solid. I also am involved in legal education. I believe firmly in continuing education. I think I better stop here and have a sip of water. I would like to add that when I started to work at the Royal, mental health was the subject of quite a number of prejudices. I noted that over the years there was an evolution. There was a drop in the stigmatization, but there is still a lot that remains to be done. My personal pathway is wanting to learn and learning my Abenaki language. During the pandemic, I participated in a learning group for a year and learned Abenak.
But other giants, such as the Honourable Marie Sinclair and Phil Fontaine, have shared with me their wisdom, and we have had great discussions about our strengths as First Nations people. Throughout my life, I have also received wonderful mentorship from elders. When the process began to replace the irreplaceable Justice Moldaver, a number of my friends and colleagues encouraged me to apply. I humbly filled out my application in French and in English. I must have reread my submission email at least 10 times before I pressed that send button because I was so afraid to have made a mistake. I was overjoyed when I received the call advising me that I had been selected for an interview with the advisory committee. At that moment, I became that 9-year-old girl again. Je suis ici avec vous.
I'm here with you today, and I say very humbly that I hope that my life experience as a Franco-Ontarian, Indigenous mother, my experience in the labor law and judge will contribute to something positive at the Supreme Court.
A different path to get there. And I hope my different path will allow it to make a lasting contribution to the court. On a deeper personal note, I'm going to give you some fun facts about myself. My husband is an engineer and a lawyer. I have 2 sons. I have to say I'm extremely proud of them, and they're both artists in their own way. They are really the 3 most important people in my life. We have 3 dogs, Max, Pixie, and Zorro. You've heard me right, 3 dogs. For all you cat lovers out there, rest assured, I have nothing against cats, and in fact, I've been asking for one for quite a while, and my husband keeps saying that it's not a good idea because of his allergies, but I think that we're going to keep working on him. Oh, and I forgot to mention, we also have 8 chickens and a gecko named Lizzie. I'm also a painter, and this is a hobby that I've enjoyed with my father that we started out together when I was a teenager. I love to read, and when time permits, I love to sneak in a little round of golf. Donc avec ce, je suis prête à répondre.
With that, I'm ready to answer your questions.
Merci beaucoup, Madame la Juge.
Thank you very much, Madam Justice. We will now move into the question period.
A reminder of the 5 minutes that we all have at our disposal for those in the room, because as we will soon see, this will be a really kind of a post-pandemic kind of session, in the sense that we will have approximately half of our questioners in the room and half of our questioners online. For those in the room, you can see the time right in front of your noses. So thank you for that. The first questioner will be Senator Mobina Jaffer, who is the chair of the Senate Legal and Constitutional Affairs Committee, joining us online, virtually. Senator Jaffer.
Thank you. Thank you very much. Madame la Juge, au bon samen.
Madam Justice O'Bonsawin. I want, first of all, to welcome you to Ottawa and also to congratulate you most sincerely on your appointment to the Supreme Court of Canada.
That Canada's most vulnerable populations benefit from feeling, seeing, and heard through the Supreme Court's decisions. Perhaps you could explain as well your vision of equity versus equality in Canadian society.
Just one moment, please. I'm just wondering, is it possible to see the members on the screen in front of me when they speak?
We'll try to get that fixed. For the moment, we can see them on the left and the right, but
Okay.
ideally we will see them right in the center as well.
Okay. Thank you very much. Thank you. Now I can see you. I think it's very important for people who have issues with mental illness to be seen and heard. It impacts so many in our population, and I'm sure many of us here know someone who's been impacted by mental illness, either personally or as members of their family and friends. I think that in order for them to be part of society and to feel involved, it's important for them, as you said, to be seen and heard. And that's all part of inclusivity, and it's part of our charter values about having equality and dignity. With regard to equity versus equality, these are all principles that are very important related to the charter. And again, I would say that people who are affected by mental illness need to be supported throughout our community, because at the end of the day, everyone is value added, and we can never forget that. So I would say that we always have to remember our charter values and make sure that we're a very inclusive society.
Madam Judge Bonsavan, you know, you have spoken the difference between equality and equity. And I would like you to share our vision of what you mean in the difference between treating people equally or with equity.
Well, I think that everyone has to be treated equal under the law, and that I've spoken about when I was asked that question in my application. When I think of equality, I would think that that's protected under Section 15 of the Charter, and it's something that we should all aspire to achieve as part of members of our society, Canada throughout. With regards to the issue of equity, I think they go hand in hand, and that I think that's all that I have to say about that issue.
So I want to ask you also about, given your expertise with Gladue principles and your doctorate, how do you think should be incorporated into our judges training, continuing education training, the Gladue principles, Gladue training? You've talked in your questionnaire about the different training you think should take place, but I'm interested in how you think would Gladue principles be incorporated in judges training?
I think it's essential, and I've been a strong proponent about talking about Gladue principles. I've been invited to speak at many conferences about this issue, and whenever either the CIAJ or the NJI ask me to attend, I'm always a willing participant, because at the end of the day, we all have a responsibility as sentencing judges, judges who also do bail hearings under the criminal code, to apply to look at the background of Indigenous accused when they appear in front of us, because it's that understanding that's required for judges to be able to make a fulsome decision by looking at the facts, what's in front of us as the issue, but also looking at the particular background of those Indigenous accused. So I always said it's extremely necessary, and I think it should be something that we're constantly striving to achieve, to be fair when these people appear in front of us.
Thank you.
Thank you very much, Senator Jaffer. The next question goes to MP Randeep Sarai, who is the chair of the Standing Committee on Justice and Human Rights.
Thank you, Vice Chancellor Elaine Rossi. Just hours before, during our Standing Committee of Justice meeting on this nomination process, the nomination of Justice Michelle O'Bonsawin was described as landmark, historic, and episodic, and that to a group of elected parliamentarians. However, as a young South Asian being born to immigrant parents in the late 70s, I've witnessed a lot in the past 40 years. Always a dreamer and an optimist, I always believed that Canada would be a place where everyone felt welcomed and is a part of the fabric. But I also never realized the daunting challenges that it faced in terms of reconciliation and healing. But I believe the future is a lot brighter. Just look at us today. We have a South Asian Muslim senator who heads the Justice and Constitutional Affairs Committee, a Sikh member of Parliament who's the Standing Committee of Justice chair. And if you look at this room, the abundance and variety is even more abundant. And we have a nominee that is nominated by an Italian-Canadian Attorney General. And if I went around this room, it would even be broader. So Justice O'Bonsawin, as a trilingual woman, Abenaki member of the Odanak First Nation, mother of two, how do you think your life experience and background will assist you in the role as Justice of the Supreme Court of Canada?
Well, I'm hoping that my background, because I am an Indigenous person, I'm a Franco-Ontarian, I grew up in a very small rural community. I'm hoping that all that life experience will bring me a unique perspective that hopefully is going to be beneficial to the Supreme Court of Canada. I also think that my professional experience in mental health law and my extensive research that I performed for my PhD with regard to the use of GLADU principles, and if it's possible to apply them in the forensic mental health setting. So what I would say is I would hope that this experience, both background, personal, and also my professional experience in mental health, Indigenous issues, and also the perspective of the labor and employment that has that human value to it, is something that's unique to me and would be beneficial to myself on the court and hopefully to the court as a whole.
Thank you. You've also accomplished a lot in a short period of time. You've become a lawyer, a justice, a mother, completed your master's and PhD all at the same time, and you've had mentors along the way. But how do you see yourself mentoring others who may come from rural, remote, or underrepresented communities in Canada?
I really think mentorship is the key. I've always had mentors throughout my career. From when I started at Canada Post, I had great labor mentors and them there. When I joined the Royal, I had great people who showed me how to work the forms, because this is a very complex issue, and external counsel that helped me along the way on our court, as I spoke of Justice Hackland. And because I've had that mentorship, I've always thought it was important to share that with the youth and with either the students or the junior lawyers. And I've really done that throughout my career, because I think that we share with them to hopefully help give them and share our insight and experience, but we also learn from them. And I think that we all have perspectives to share, and I think mentorship is really very important at every stage of your life. It's not only when you're first a lawyer, because I've always said, see, I've had a mentor when I started law, when I moved into labor and employment, when I moved into mental health, the Superior Court, and it's really just made me a better person. So I hope to do that for others, and I have done so for quite a while.
Thank you. As the first Indigenous woman judge appointed to the Ontario Superior Court of Justice in Ottawa, did you face any challenges when applying to the bench?
No, I have to say, to be honest, I didn't face any challenges. I think that I met the requirements because I had my 10 years of experience as counsel. I think it was helpful to me because I was bilingual, and sitting in Ottawa as a very bilingual city was helpful. And I had something I think a big different to bring to the court with my mental health experience and my criminal background in forensic mental health. So to be honest, I didn't face barriers.
Thank you. I think I'm out of time, but I again want to wish you and congratulate you on this momentous appointment.
Thank you. I appreciate it.
Thank you very much, Mr. Sarai. J'inviterai maintenant le sénateur.
I would now invite Senator Pierre Dalphond. Quite. I want to, first of all, congratulate you on your life path. At age 9, you said that you wanted to be a lawyer. That's what you told your parents, and here you did your law at common law in French at the University of Ottawa. And also you attended a conference in second year in response to a question. You said that the ideal judge would be a woman, bilingual, of Indigenous roots. And you didn't look back. And then in 2017, you became a judge of the Superior Court of Ontario, and then you moved on to also include tele-legal services. And now here you are, recommended by the Independent Advisory Board at age 46 to be elevated to the Supreme Court. So what's your next goal, Madam Justice? I guess I have to be honest, I'm 48, not 46. But very often, they always say you're younger, but when you're a judge, sometimes it's better to look a little older. Well, my next dream really is to have the pleasure, if possible, joining the Supreme Court, to add my voice as well as I can to reflect my professional and personal experience to work with my colleagues on decisions that are just and that will be good for all Canadians. And in that way, I will achieve my dream. I will begin with this first new dream, but maybe there'll be others that follow. But I'm very happy and lucky to be here today. Thank you for your answer. Courts don't participate in the political process, and sometimes it's very difficult to make a clear distinction between the law and politics. Peter Hogg has written and spoken about that. What is your vision of a dialogue that he wrote about between the Supreme Court of Canada? Well, I have to be a bit more limited because we each have our role to play. You as parliamentarians play a legislative role. We as jurists, well, it's different because we don't insert ourselves so much in social norms. So there is a very clear distinction that can be made between the two. And as a judge, it's important for me, as someone who's impartial, who would look at a file and make a decision based on the matter, the grounds of the matter. So I'll just follow my path, and I think you should follow yours. I think that's an excellent answer, and I'm so happy that you are the first woman having done common law in French to be elevated to the Supreme Court of Canada, who is Indigenous, and I must say that we congratulate you and look forward to your decisions. Thank you, Senator Dalphond.
Now, the next questioner is MP Rob Moore.
Thank you, Chair, and thank you to you, Justice. Congratulations, number one, on your appointment. This is a huge appointment, and we know the important role that the Supreme Court of Canada plays. We know their decisions have an impact on all Canadians. So I congratulate you, number one, on your appointment, and I wish you very well in your deliberations, which will be over the next many number of years. So you've spoken about access to justice and your life experience. You've seen issues around access to justice. In particular, this is something near and dear to my heart. But could you comment your perspective on access to justice and victims' contact with the justice system, and how judges can help facilitate a system that all Canadians see themselves in, particularly victims?
All right, so that's a loaded question. I've broken it down into really three categories. So I'll start off with access to justice. I think that we've seen a huge improvement, to be honest, in the last couple of years because of the pandemic. It's created access to many Canadians to have access to justice because now a lot of court processes, court filings can be done by electronic means. Is it a perfect process? Absolutely not. There remains many Canadians that do not have access to electronic means to be able to have that. I think there are issues with access to justice that have to be looked at, which are social issues, and a lot of it has to do with monetary issues and poverty, but that I'll leave for the legislators to deal with some of that. With regard to victims, they definitely do have a role to play. As you know, they have a charter. They have a right to be heard. So when we do criminal trials, there are provisions in the criminal code that permits them to appear in front of us, to provide us with their declarations. But let me just step back. When they appear in front of us, there are provisions under the code that do provide that, for example, screens could be up so that when the person testifies, she or he will not see the accuser. So norms could be put in place. And I think as a judge, a sitting judge in criminal court, I'm conscious of that. and mindful, because we have to be conscientious of those things. They also have a right, when it comes time to sentencing, to provide us with a victim impact statement. And those, I can assure you, are considered closely when we're sitting on sentencing. And how can we facilitate these issues? Well, it's to be mindful of it. I think continuing education is always the key. I know that the National Judicial Institute and the CIAJ do a lot of work to put programming together to ensure that judges, especially those sitting in criminal justice files, do take into consideration the issues of victims' rights and the obligations that we have towards them under the criminal code.
Thank you for that. And quickly, I only have a minute left, so I'll try to ask this quickly, but you, in your application, you stated a judge must remain free of influence or pressure, must not engage in public discussions regarding matters before the court, and avoid commenting on political issues. But we do know from time to time sitting judges are invited to, for example, write articles and make speeches on general legal policy issues. What parameters do you see should be in place or should be exercised by sitting judges, including yourself? What should be imposed on yourselves in making speeches or writing articles as you now embark on this new appointment?
Well, we have ethical protocols that we have to follow, and in there it's very clear that we're to stay clear of commenting on issues that may arrive before the court. So I think that we're all independent as judges, so I don't want to comment for others, but myself, I know that I'm mindful of the idea of what's within my toolbox and my playground, and I know that I could speak about certain things, and there are others that I cannot because they're before the courts. So it's really an individual call depending on what the issue is that we're speaking about.
Thank you, and congratulations once again.
Much.
Thank you, Mr. Moore. So we are coming back into the room. The next person is MP Jaime Batiste.
Gwe. I was really proud to hear you start off with your first few words in your Abenaki language. As a Mi'kmaq person, I was able to understand a lot of it. We share the same way to say greetings. We're also linked by the Treaty of 1725 and the Wabanaki Confederacy, and I'm deeply honored to be able to ask questions as an Indigenous person for the first time to an Indigenous nominee, and that's a great moment for Canada, I believe. My question is about legal pluralism. All across law schools in this country, we learn that, we have a common law, we have civil law, and we also have Indigenous laws. What do you feel how does your nomination to the Supreme Court help promote and shape Indigenous laws in this country?
I could tell you, I'm a judge first and an Indigenous person and a mother and a Franco-Ontarian afterwards. So I think that what's important for me to remember is my roots and the voice that I bring, my life experience, but also my background as someone who's worked in mental health law, Indigenous issues, and also in labor and employment and human rights. So I can't comment much further about what kind of a role these issues could play, because it's something that definitely I think is on its way to the Supreme Court of Canada. But I could tell you that I have my voice as one of 9 judges. Hopefully I'll have one of 9 voices on that bench. So let's just be clear. And unfortunately, I can't say much more than that.
During the questionnaire part of your interview, you had mentioned that the important role that judges play, the decisions may help protect vulnerable populations. In an era where we're seeing the calls to justice from the missing and murdered Indigenous women, and we realize in Canada that Indigenous women have been perhaps the most marginalized and one of the most victimized people in Canada. I'm wondering what you feel the importance of for Indigenous women out there to see you now as a nominee at this level, and what do you think that it is going to do for not just Indigenous women in Canada, but for those young Indigenous women who you mentioned as a 9-year-old yourself were dreaming of this, to see this in person today? What do you think it means to them?
Well, I'm hoping it's going to inspire them, because I come from a very small rural area where I was told, "Oh, Michelle, you're not going to be, you're likely not going to be a lawyer because you come from this small town in Northern Ontario." But at the end of the day, if you work hard and your heart's in it, you could go and do what you want. And I'm hoping that young people, female, Indigenous women also, will see that anything is possible if you set your mind to it and you surround yourself with great people, because I've stood on, as I said, the shoulders of giants throughout my life. They've helped propel me up, and I think that's really made a difference. So I'm hoping some will feel inspired.
In the last minute of questions that I have, I'm wondering if you could talk to some of the key Indigenous teachings that you've received in your life that have helped shape where you are today.
I think being humble, which is the first one, it's really important to recognize our place where we're at in the world, because we have to work our way throughout life by remembering who we are and what our roots are. And no matter where we are in society and how far we move up, we always have to remember where we come from. I think honesty has always been extremely important in my life. I'm a tell it as it is person. I don't sugarcoat things. And I've really learned that from my roots, how it's important to be honest and to be compassionate and to love others how we want to be loved.
I only have 20 seconds, so I'll save that and just say Walal in our Mi'kmaq language, Walaliek, for all of us who hoped and dreamed that this day was possible, to see an Indigenous nominee and to hear you today, just as an Indigenous person and as an Indigenous person who was part of the Indigenous Bar Association, just how proud you've made us today.
Uliuni.
Thank you very much, Mr. Batiste. The next question comes from Senator Peter Harder here in the room.
Good afternoon, Judge. I wrote in my book after you finished your opening comments, so normal and so exceptional. And I think that those are the characteristics that have come through in your questions and responses, and I thank you for that. I'd like you to comment a little bit on the expectations that Canadians generally, and certainly Indigenous Canadians, have with respect to your nomination, and the priority that so many of us share in terms of the calls to action of the Truth and Reconciliation Commission. There are a number that speak directly to justice and legal issues. I won't go into them in detail, you know them, but I'm particularly interested in the role that you think justice and judges can play in promoting reconciliation between Indigenous and non-Indigenous peoples.
I think it's to start by having the conversation. Because I always tell people, if you want to learn about reconciliation, you got to start by knowing our history and looking at the executive summary of the TRC. So I always tell everyone that's the first place to start. And I think that by going through that understanding, that personal understanding, then we could set in motion responses to the TRC. And I'm but one person, hopefully, of a 9-member court, but I think education is the key. I think talking about the issues, because at one point everything was more hidden. We didn't talk about residential schools and the intergenerational impact that this had on our family members and our friends, and the impacts that it had on mental illness. So I think to have that active discussion, I think that's a very direct response to the TRC recommendation. And then it's for legislators and society as a whole to try to implement movement forward.
Thanks very much.
Just a follow-up question. In your time on the Superior Court of Ontario, how did being Indigenous and coming with a perspective on Indigenous law in particular affect your role?
I think it was definitely beneficial because I think that coming back to my comment to Mr. Batiste about being humble and about recognizing what's important in individuals' backgrounds, because to be honest, in Ottawa, we didn't have a lot of GLADU type cases because that's before the provincial court. There's an Indigenous persons court. But I think that my own teachings as an Indigenous young woman have helped me along the way. And I would hope that people would say as a judge that I'm compassionate, I listen, and I make sound judgments. So.
My final question is, do you believe that Indigenous laws and traditions, legal traditions, can make an increasing and important contribution to Canada's pluralistic legal system? And how do you see that evolving in the course of what will be, at least on paper, a fairly long time on the bench? How will the pluralism of Canada's legal system adopt and incorporate as a result of your participation?
I have to say it's a bit difficult for me to comment on something like that because it's definitely, I think, something that's going to come into the courts and possibly into the Supreme Court of Canada system. So unfortunately, I can't say much more than what I've said to you already.
But by your references to the Truth and Reconciliation Commission and the calls to action, there are some clear guidance there that we can all reference in the work ahead.
Yep. Yeah, because there are separations. When you look at the recommendations, they're separated, and there's a clear section on justice initiatives and how those could be put forward. And I think everyone has a role to play, from the court system to the legislators to society as a whole.
Well, again, I congratulate you and look forward to your appointment.
Thank you.
Thank you, Senator Harder. La prochaine personne à poser la question.
The next question will go to Senator Réal Fortin. Thank you very much, Madam Justice. My sincere congratulations. I can confirm that we welcome your ascension to the Supreme Court with great enthusiasm. It's a very significant event for citizens who come under the Supreme Court. You said in your introduction that you dreamed of, I don't really remember the details, but you dreamed of being clear, sympathetic. But for being sympathetic and appealing to people, it's already done. We know that you are. But I'm afraid that my questions may be out of order given the circumstance, but I would just like to explore certain issues that are very important to me. My first question deals with official languages. We know in Canada that French and English are the two official languages, and we also know that Indigenous languages are languages that we respect because they are a type of national treasure that we don't want to ever lose. In my political party, we are very sensitive to that, but that does give rise to some challenges. How do you see this question of Indigenous languages vis-a-vis the two official languages before the Supreme Court? As you said yourself, Mr. Fortin, it is possible that Madam Justice might be limited in her answer in what she would say, but nonetheless, I give her the floor. I can speak to you about my experience and how the revitalization of Indigenous languages is important. The Abenaki language, for me, is very important. In my personal life, I've undertaken to learn my language, Abenaki. There's always the issue of interpretation that I do know is available. But other than that, I really can't say much more on that matter. Senator Harder addressed the issue in his previous question. It's very difficult for you to speak to the inclusion of traditional Indigenous justice in the system in Canada, but I understand that. But for me, in the community where I live, we've always put on a pedestal the wisdom of Indigenous people on a variety of questions in terms of legal matters. I'd like to know from you the following. How can we integrate some of the Indigenous traditions within the framework of the Canadian legislature, the legislative framework of Canada? Well, that is difficult for me to answer as well, but I can say that from my point of view, we can all work towards something at the end of the day. Everything comes from our elders, and everybody in all societies can learn from their elders, can learn the lessons that the elders have. But I'm sorry, I don't really think I can go beyond that. Thank you. I'd also like to ask you something else. I have so many questions. Access to justice and the training of judges. We've spoken a lot about that at the committee. I'm very concerned about that. But we have persons who appear before the court who are not represented by lawyers. That's very significant for the sitting judges because they're faced with people who don't understand the legal process necessarily, who are appearing before them. I know I only have 30 seconds left, but in the Civil Code of Quebec, I'm sure you know, in Quebec we have the Civil Code of Quebec that governs the civil law in Quebec. How do you, and elsewhere in Canada there is common law, how do you see that? How do you integrate that in your judicial practice? I'll be honest, I'm very limited in terms of civil law, my knowledge of civil law. I did my courses in common law at all levels. But I can commit in front of you and everybody here that if indeed I am appointed to the Supreme Court, that I will learn and I'll make it my duty, because I have two colleagues on the Supreme Court who are experts in the civil law, and they will guide me on that matter. I can, of course, do my learning. You know, I'm a lifelong student. I like studying, and I learn every day. Thank you, and congratulations again. Thank you, Mr. Fortin. Senator René Dupuis, who is with us remotely online. Thank you and congratulations, Madam Justice Obomso, when your determination is going to be a source of inspiration for many young women and young girls here in Canada. I thank you for that. My question deals with Part 10 of the questionnaire, dealing with judicial functions. You talked, and I quote you, belief in other regions of the world cannot influence or affect the way in which our Constitution will be interpreted and applied here in Canada, which has to be independent of any external forces. My question deals with the judgments of foreign courts, of other, say, Commonwealth courts, with respect to constitutional law. Rights that have been confirmed for Indigenous peoples in Canada. Do you think that these foreign courts can play a role in what comes before the Supreme Court of Canada? That is a hypothetical question, and I'm sure that Madam Justice will have to be very limited in her answer to your question, Senator, but nonetheless, I give her the floor. I think that depends on the matter that is before the court. It is a question that has to be dealt with on a case-by-case basis. What role would be played? I can't add more comment than that. There is a role that will be played by the court, and I can't add to it. So if I understand you, you're not excluding rulings from other countries' courts. On principle, you're not excluding them. I'm not saying yes or no. Here, I refer to, in Part 10, a response on question 3 with respect to constitutional law. You say that a judge has to demonstrate competency, a delicate balance between the needs of the public and individuals' rights. What do you understand by the needs of the public? I think really it's a balance between the two. Anything that isn't an individual is the public for me. That can be an institutional entity. It could be a group, something that is just not an individual. Perhaps my language wasn't clear enough in my formula, in the form I filled out, rather. But it's a balance with the charter where these values go. In the needs of the public that you refer to versus the weight. But I come back to the term need, public need. And when you have litigation, it's in the presence of an individual, but generally a social institution is different. Yes, thank you. Thank you.
Goes back here in the room to MP Lori Idlout.
Yanami sivudlang mi akswaro upigi yumavagit pilirya kasi mayatit akswaro pikkonaksutik takuminak tudlutit amaro niriyong niyang mit amisum magayarang nito nisisimagavi koyarivagit. I wanted to first thank you very much. I wanted to congratulate you. Yep. Can you add? Can you give me back my 5 minutes? I'm going to translate what I just said.
On n'a pas d'interprétation.
We don't have any interpretation. I just wanted to mention that.
5 minutes.
On peut remettre un peu de temps.
We can give you more time. Yes, thank you.
Koyanami, sivudlangmi, akswaro upigi yumavagit, pilirere simayatit pikko ng mata, amaro takuminaksutit, amaro niriyong niyang mit tunisisimagabit ang iyuarong mi. I wanted to first congratulate you on this momentous occasion, this historic occasion. I admire your work, and you are a role model to so many Indigenous women, especially, knowing that we live in a world where there are too many missing and murdered Indigenous women. You've given so many hope to so many Indigenous peoples in Canada. So I'm very proud of you for what you've achieved. I wanted to give a bit of a context before I ask my first question. Inuit, First Nations, and Métis have lived on these lands since time immemorial. Indigenous peoples have thrived with Indigenous laws. About 155 years ago, colonialism took hold, and we now live in this country called Canada. We now live in a bijural system. During the process of colonialism, the courts that have appointed you have compartmentalized the Indigenous inherent rights to thrive into land, title, and human rights. Your appointment opens the space that's needed to ensure that the court's legitimacy is strengthened to a pluralistic legal system at the highest level. How will you, as an Indigenous justice, work with the Supreme Court of Canada to lead in the potential for Canada to be in a pluralistic legal system that reconciles with Indigenous laws of which have purposefully been ignored and hidden? In other words, how will you ensure that Indigenous laws are seen and heard? Oyanami.
Uni, for your question. I am a voice at the table. I bring my background as an Indigenous mother of 2 sons and everything that comes back, I guess, with all of my background. So what I can tell you is I live my traditions. I bring these traditions and my heritage to the table. I'm a voice of, hopefully, a voice of 9, whereas we make our decisions based on the file that's in front of us and the facts and the law that's as it's presented. But I can tell you that I do bring my voice as an Indigenous person, and that's what I have to offer, in addition to my own experiences and also as my work experience. And I think especially in my research into GLADU principles and how they apply to sentencing, and I hope that experience is going to be helpful to the court. And also on the mental health aspect, because as we know, our communities were deeply affected by residential schools and related issues, and there's intergenerational trauma that has affected the mental illness of our brothers and sisters. So I think it's to be mindful of that and to bring that experience to the court.
My final question is about Indigenous languages and where it could sit within at the highest of our courts. This morning during our hearing, I had asked a question in my language as a person with and my question was not properly interpreted into English, and I wasn't able to correct that question. And I think that is often a reality that is experienced by individuals in the court system who have non-Indigenous lawyers that don't understand them fully. What role do you think the Supreme Court can do to make sure that Indigenous-speaking people in the justice system are better heard in terms of seeking justice?
I think it's a bit difficult to provide an answer to that question per se, but I could tell you that in my experience on our court, we have translation services. I saw this morning, unfortunately, it didn't work out in your situation, and I would hope that if we appear in front of courts with our language, that we would have proper translation.
Thank you, Ms. Idlout, sorry. Next questioner is Senator Kim Pate.
Thank you very much and welcome. Congratulations. I've heard in the last few days from many Indigenous women all across the country at all levels, and there's a lot of weight on those shoulders that sit in before us. And as I want to follow up on some of what was just raised by previous MPs and my colleague senators, and this morning Minister Lametti spoke about the importance of the incorporation of the application of Indigenous laws and traditions and the need to ensure that we do build a more pluralistic legal system. As we move forward in the spirit of reconciliation, in light of the calls to action that you've referenced and many others have, of the Truth and Reconciliation Commission, as well as the calls for justice for the missing and murdered Indigenous women and girls inquiry, as well as the stated objective of this government to reduce mass incarceration of Indigenous women, particularly in light of the reality that now and over the past 4 decades, every effort to reform the system has paradoxically resulted in inadequate protection and support for those very Indigenous women who've experienced victimization and the results of colonial racism, in addition to the astronomical increase in the rates of incarceration of Indigenous women in particular, to the point that they now represent half of federally sentenced women serving 2 years or more, 3/4 and more of the women serving provincial sentences, particularly in the Prairie region, and an astronomical 95% to 100% of the young women and girls in the youth system in the Prairie provinces and Northern Territories. What is your view of the role and importance of the judiciary in remedying these wrongs by decolonizing current approaches, including by ensuring the application of Indigenous laws and traditions?
Well, I'll start off by recognizing the number. I think it was Dr. Zinger's last report that showed that Indigenous women are close to 50% of the incarceration rates. and we're less than 5% of the population. And you and I have worked on this in the past when you were with the Elizabeth Fry Society and I was general counsel at the Royal, where we would face these issues where we had Indigenous people in the system. I think that education is the key. That's what I would say is my part of talking about GLADU principles and how these can improve the process for judges to get an understanding of how 718(2)E of the Criminal Code and in the bail provisions, how those work, how the Supreme Court of Canada sets that pace. Unfortunately, I can't comment on that, but I think, and I always repeat myself when I say this, but education is very important. It's the key at all different levels with public education, with regard to the different reports that have come out. I also want to mention the Vien report that talked about these issues also. But I think that it's to have the conversation. And unfortunately, I can't comment further with regard to what the Supreme Court itself can do other than to be mindful of these issues as they appear in front of the court.
Thank you for that. And I'd like to ask you to reflect a bit on your past experience as MP Idlout raised the issue of the racist and sexist interpretations often of information. In fact, it's the reason many of us don't even refer to Section 718(2)E as GLADU factors, because Ms. GLADU herself was treated in such a racist and misogynist way. And so I'm curious as to how you, as a judge in the past, have taken those, have tried to bridge so that those interpretations that are often presented even by counsel before the judge, sometimes replicated, as we know, by judges' decisions, how you have in the past addressed those issues and what you see going forward in terms of ways that judicial education could remedy those circumstances.
Well, I think every judge, and I myself, have this obligation, and we saw that in the GLADU and IPELI decisions, because we all have a role to play. I wrote about this in an article before where the people who appear in front of us, lawyers and ourselves. And I have had issues, and I've seen this more on the bail side of things, where I'll recognize a name as Indigenous from my community or from a sister community, for example, where I'll ask, and this is, we see this unfortunately with self-represented accused. So I remember telling that man, you know, have you told anyone that you're Indigenous? I recognize your name. And he said, well, no, I haven't. So I had asked duty counsel who was there to have a discussion with him to educate him as to what that meant, because when they're self-represented, they really just don't know. And that comes back to education of judges, where it's important for everyone in the legal community, not just judges, but lawyers also, to understand what it means to represent an Indigenous person and to ask the questions, because unfortunately, at times, they'll take the client as they come and they don't ask more information about the index offense and what happens. So I think we have an obligation in the legal system as a whole to ask the questions about the Indigenous person's background. What kind of an impact did this have on the index offense, and what led them to be in front of us? Thank you.
Thank you, Senator Pate. We are going back online to MP Carolyn Finley.
Thank you, and thank you, Justice Obonsawin. It's, I think, a proud day for all of us to be here talking to you, whether it's in person or virtually, as I am from British Columbia. So thank you for the opportunity. And with that, I appreciated you saying that you see yourself as a lifelong learner, a lifelong student. Certainly your degrees would bear that out, but I think you meant that much more broadly. And a role to be played with judicial education and training that would be ongoing. So I'm I think that's very good to hear that. Your PhD thesis, which you defended in December of 2021, as I understand it, at the University of Ottawa, is under embargo. The embargo prevents researchers from reading it to assess research competence and judicial philosophy. My understanding is that to embargo a thesis is quite unusual. So could you just clarify why that was done?
I think it's unusual because my understanding is not many judges actually go through the PhD process while they're still sitting. So I think what happens is that when I had drafted it and afterwards when it was successfully defended, I sat down with my supervisor and we discussed what were the next steps. And the discussion was had about whether or not we should have the application for an embargo because I am a sitting judge. And so that decision was taken at that time. Will it be maintained at this time? I can't really tell you. It depends as time moves forward. But it was a preliminary decision given the fact that I'm still a sitting judge at this time.
Thank you for that explanation. And is there anything you might want to comment about your thesis or the relevant research in a general way that you think may assist in your new role and responsibilities, or is that not possible then?
Well, I could talk to you about globally what it was about, and I looked about the history of all the different commissions, inquests, reports that were done into Indigenous issues, how that impacted. Senator Pate asked about the high rates of incarceration and how we've seen the government had responded in the mid-90s by amending the criminal code to add the specific provision of 718(2)E into there for judges like myself who sit at the trial courts to take into consideration the individual personal background of Indigenous accused. And then the question was, can we apply that in a different context, looking at the forensic mental health system? And specifically in Ontario, there was a Court of Appeal decision called Sims that talked about the fact that, and this was someone who was found not criminally responsible due to mental illness. He was Indigenous, and I think he was of Cree background. And the question was, what kind of a consideration should be given at the review board level? So the criminal code creates review boards throughout Canada that are responsible for having yearly hearings to review the status of unfit to stand trial and not criminally responsible individuals. And the court had said clearly, and again in the last year with a more recent decision, that there should be an understanding by the review boards of these principles. It's not mandatory under the provisions of the criminal code, but it is very important for it to be in consideration. And I had looked at just the case law and did an analysis with regards to what had occurred in the last years. I think SIM came out in 2006, and it was looked to see were they considered the principles and what did they do with it when they were looking, because they look at what kind of conditions are imposed to the person. Are they still a risk to society? Should they be in the system or not? So it's a whole multitude of considerations.
Thank you. I have little time left, but I appreciate you expanding on that for us and wish you every success in as you move forward.
Thank you very much.
Thank you, Ms. Finley. On va rester en ligne pour le moment.
We'll stay online for the moment and now move to Senator Boyer. Yvonne Boyer.
Chair, and welcome, Madam Justice Obonsawin. As co-chair and on behalf of the Indigenous Senators Working Group, we'd like to thank you for taking the time to meet with us today and to congratulate you on this historical nomination. We're beyond thrilled that one of our Indigenous sisters has been nominated to the Supreme Court of Canada. We've come a long way, but we've only really just begun. I'd also like to congratulate you on your recent PhD, and I'm glad you just expanded on it a little bit because that's something that I wanted to talk to you about. And I also know that the Supreme Court hears about 55% criminal law cases. So how do you see the Gladue principles blending and enhancing the access to justice for Indigenous people? And how can the Supreme Court influence the lower courts to implement these important principles?
Well, I can't comment specifically on how the Supreme Court can influence, but I could tell you that it's definitely a consideration that's mandatory under the code, and that has to take place in when we're doing sentencing and bail hearings. So that's mandatory under the code, and it's not, I may want to do it one day depending on the facts and may not. It's an obligation that's required of every judge who sits, especially in sentencing and bail hearings.
Mm-hmm. I have another question that's a little bit different, and I know we've heard a lot about the Gladue principles and we've heard a lot about the sentencing and your good work. I have a question about what are the greatest challenges you've had to deal with in your career as a lawyer and a judge as an Indigenous woman, and what advice you would give a 20-year-old version of yourself?
Be patient, patient, and more patient. I've been very fortunate. It's not been an easy road. I have to say a woman in labor is not easy. It's more male dominated. So that was something that it takes patience and time, and you work your way through the ropes. So that was a bit different. As an Indigenous person, I've been quite fortunate, but I will tell you about an experience I had sitting on court the day after there was a comment that there was a senator in the States called Pocahontas, and I was sitting in court that day. There was quite a few individuals. It was a long motions list, and as I'm reading an order, a specific order, I could hear a lawyer speaking to a junior lawyer, and at one point I hear that lawyer say, "Oh, she's a Native Indian. She's our Pocahontas of the North." And for me, that hit me square in the forehead, and it didn't go over very well. And when the lawyer came up, not the one who said it, but the receiving lawyer, I put it on the record that I had just been referred to as Pocahontas of the North. And I took that back home to my two sons, and I said, you know, this is a teaching moment. Because at the end of the day, it doesn't matter where we are in society, we all face issues. And what's important is how you deal with it. And how do you have to speak out when that happens. And I was happy that I put it on the record. And then afterwards, I dealt with it in other ways. But I think when these types of situations and discrimination happen to us, we have to respond, and we have to make sure that we're vocal and tell them that it's not right, because otherwise it just continues.
Thank you. Yes, it does. And I'm thinking that all of the work that you've juggled, the motherhood, the being an Indigenous woman, being a lawyer, and moving up on the bench is just so admirable, and we're very happy that you're there. So thank you. Thank you from all of us.
Thank you very much.
Thank you, Senator Boyer. We are now back in the room with NP Lena Diab.
Thank you very much. Madame la Juge, premièrement, je vous félicite.
First of all, I want to congratulate you, Madam Justice. It's an honor for me to be part of the Standing Committee on Justice and Human Rights, and also to participate today in this historical session. It's a landmark. With you as the new nominee to the Supreme Court.
Indigenous person to be nominated to Canada's highest court. And as you said, I think you probably have to frappe la tête to sort of, is this real? As you spoke in your introductory remarks about your upbringing, your family values, and how from an early age you said, je veux être une avocate, at a time when to many, that would have been a nice dream to have. I personally identify with a lot of your personal background as a small girl growing up at a young age in a small rural town in Lebanon. At the age of 7, 8, and 9, I would often get asked, what do you want to be? And I always said, I want to be a lawyer, not knowing what a lawyer was, but it sounded good at the time. And okay. Moving back to Nova Scotia at the age of 11, having to learn in English, being the oldest of 6, needing to always show that, you know, I can do it, and determination, and getting my education, going to law school, being admitted to the bar, at the same time having 3 children. So I identify with your ethics, with your family, with your motherhood. I say to you the following question: what can you do now, being in the position you are going to be in, where so many people are looking at you and are proud of your achievements, and are looking at themselves when they were young, or are looking at young little girls that aspire to be anywhere near that? What can you do in your position to give them hope and to give them encouragement?
I think it's to do the best job as I can, because if I have success, I think others have success. And it's to work hard, to remain humble. And I think I've always done this throughout my career. I speak a lot at universities and high schools, and it's to share my story with others, because I'm hoping that they'll be inspired and they'll say, well, you know, I come from a reserve in a remote area, or I come from a little town where no one knows where it is, or I face other adversities. And I think that if they could be inspired to learn that if you work 110% and you put your head down, things can happen, and you can make things happen, and, you know, miracles happen. I'm here today. I was a long shot, so.
I have to say thank you for sharing a little bit at the end about your personal life. I didn't research you as much as others. I didn't know if you had any children, or, you know, about your background, your father. You talked about your father, your mother. So I want to thank you for that, because it really personalizes that we are human. We have backgrounds, we have families, and, you know, we are mothers. We have to take care of our children. Question for you: when you retire years down the road, it's okay.
I said I'm 48, right?
I know, and that's okay, but we have to work our way towards that. What would you like your legacy to be at the Supreme Court? And what else in the many years to come can we see Madame Michelle Aubon-Sewin? What can we hear?
I hope that they'll say I'm a hard worker, I'm approachable, I'm sympathetic, and I'm a good listener. And hopefully they'll say I make sound decisions.
Merci, Madame la Juge, and we look forward to reading those decisions. Merci.
Thank you very much, Ms. Diab. I now turn the floor to Senator Brent Cotter.
Thank you, Dean Roussy, and congratulations, Justice Aubon-Sewin, on your nomination to the Supreme Court. In the communities where I hang around, particularly in the world of legal education, your nomination is being celebrated. I should also say, parenthetically, and I hope not too flippantly, it's nice to have another left-handed judge on the Supreme Court of Canada. My question is a fairly serious one, and it relates to reconciliation, broadly conceived, and I realize that Dean Roussy may rule me out of order at some point. A story first. I taught on a number of occasions in the summer program at the Indigenous Law Centre at the University of Saskatchewan Law School. Visitors used to come and give lunchtime talks to soon-to-become law students. On one occasion, an Indigenous lawyer came and spoke about what it would be like for them when they started law school, and he used land law as an example. He said that many people of Indigenous ancestry think about land in traditional ways, as we've heard. First, that land is fungible, that is, one piece of land is the same as any other, and that land is inalienable, that is, it's not capable of being bought or sold. But he said, when you students come to law school, you will learn that European traditions of land law are not just different, but the opposite. That is, each piece of land is unique. And secondly, that most of it is alienable. That is, it can be bought and sold. This was an insightful moment for me, a 30-some-year-old white guy who hadn't understood much of this at all. But it's a small example of the challenge of reconciling Indigenous conceptions of law with those of the more conventional European conceptions. And I'm not asking you to answer the land law question, and they're not even questions just for you, but also for legislators and the like. But is it possible for you to speak more generally about what reflections you have on how we should think through the challenge of reconciling Indigenous and traditional conceptions with those that are from the more conventional conceptions of law that we have?
That's a bit difficult to answer, because this is definitely a question that comes or will go to the Supreme Court of Canada. And in our language, land is Nakina, and we all come from it, and we cherish it, and it has much value in our culture. What I would hope is that these concepts are well explained in the files as they go forward, because as you know, we make determinations based on the facts, the law, the arguments as they're presented to us. And I would hope that these things that you're speaking of would form part of that to educate the court, and that way they'll be able to make a decision based on what's been presented to them.
Thanks. I have a second question that's related to education. You mentioned that communication was important, particularly in fulfilling the aspirations of the Truth and Reconciliation calls to action. And in that context, two of the calls to action call for law students in a mandatory way to be educated in Indigenous traditions and laws. Similarly, lawyers, but not judges. There's not a recommendation that calls for judges to go down that road. That respects judicial independence, and as you noted in your reference to the ethical principles for judges, some caution about judicial education being judge-initiated and the like. But the fact that it doesn't appear in the calls to action and is not prescribed anywhere kind of invites this question about whether or not you see a potential role for yourself as championing from the inside education, learning, understanding for judges so that they can do the best job they can on their courts.
If you look at my application, I've done that since I joined the court in 2017, because for me, education is the key. And I'm always talking about Gladue principles, about Indigenous issues. And I think it's essential, and I've done that in the past, and my hope is to continue talking about how Indigenous issues, for example, with Gladue principles, how it's important that they're properly applied at the trial level, because those are key and these impact our incarceration rates. So,
thanks very much, and congratulations again.
Thank you.
Thank you, Senator Cotter. We're going back online to MP Larry Brock.
Thank you, Chair. And Madam Justice O'Bonsawin, it is my distinct honor and privilege to congratulate you on this marvelous achievement. My riding is from Brantford Brant in Ontario, also home of the largest population-wise of the largest Indigenous nation in Canada, that being Six Nations of the Grand Rivers. So on behalf of the Six Nations and my riding, we sincerely congratulate you.
Thank you.
In my former career as a Crown Attorney, I had the distinct honor and privilege to actively participate in prosecutions in Indigenous People's Court. I did that for a number of years, and I know that you've made reference to that Indigenous People's Court in your home jurisdiction prior to your appointment. And I know that from time to time we hear various courts across this great country also speak about their efforts to resurrect Indigenous people's courts. So I'd like to hear your thoughts on mandating that from a judicial perspective, what you think about mandating that every province should have Indigenous people's courts. I'd like your thoughts on that. And secondly, ways to improve the participation in that courts outside of the traditional format where a person can only attend that court where they want to accept responsibility, and expanding that to the trial division and even expanding that into civil and family court. Thank you.
For your question, Mr. Brock. Undoubtedly, Madam Justice will be limited in her comments, but perhaps she can offer some general comments on the issues that you raised.
So with regards to mandating it, unfortunately, I can't provide much opinion with regard to that. That's definitely a legislative and social more aspect, not for someone in my position to opine on. About who should be involved in those, because I haven't worked extensively with the Indigenous Peoples Court, and it's not in my purview. I can't provide you much more information by way of an answer with regard to that. I'm sorry.
Okay. You spoke in one of your responses to one of my colleagues regarding your thoughts on the access to justice being greatly improved as a result of a byproduct of the pandemic. But there's also a negative aspect that I want to explore with you. With the reduction in access to legal aid in many parts of Canada, there has been an increase in the incidence of unrepresented accused and litigants before the court. What, if any, concerns do you have regarding that development, and do you have any thoughts about what could be done?
I can't provide an opinion with regard to that, but I can say that unrepresented individuals in front of us is not, a lot of times I would say, is not the best for those individuals because they don't have the legal expertise to know how to navigate through the system. And I think it's essential for those who appear in any level of court, and it could be on a family member matter like it could be on a criminal matter. I don't think it makes a difference, but I think that representation, if possible, is definitely beneficial to that individual to understand what his or her rights are and how the procedure should move forward.
Thank you. In your questionnaire, you stated, quote, "I have also seen how different Indigenous perspectives can be from the colonial history of much of the Canadian population, while still recognizing and embracing all our unique perspectives, which are the fabric of our country." You also noted a Supreme Court of Canada justice comes with a variety of experiences and expertise that necessarily informs without interfering with their responsibility to be impartial and independent. This is key to all judicial positions, but more importantly to the Supreme Court of Canada. Can you elaborate on those thoughts? And secondly, how should the distinct perspectives and life experiences of justices on the court inform their work given their responsibility to be impartial?
I think at the end of the day, our first role is as a judge who's impartial, and our backgrounds all inform how we live and how we perceive things. And I don't think we can get away from that. But I think that it's our obligation to be impartial. Our backgrounds will sometimes educate our decisions, but I don't think they're necessarily the driving force that lead us to fall a certain way on matters that are before us.
Thank you and congratulations.
Thank you.
Thank you, Mr. Brock. On va rester en ligne un instant.
We will stay on lane and move to Senator Bernadette Clement. Welcome.
Room with you, but I do want to tell you that I'm in my home community of Cornwall, and that is located on the traditional territory of the Mohawk people of Akwesasne. Je vous ai entendu dire dans votre discours.
I heard you say in your opening statement, "Look at me, just watch me go." That bears witness to an attitude that is free and to great perseverance. I thank you for that, and I offer you all my congratulations today. I say it with a smile. Maybe you can hear the smile in my voice. You can't see me, but you hear me.
Your work as a legal clinic lawyer, if you could explain how your work as a legal clinic lawyer has shaped your career in law. And the second question is about being the first. So being the first is, of course, a place of great honor, but it can be a place of great pressure. a place of vulnerability, especially when you are in such a high profile job that might take you away from your community at times, away from your source of strength and comfort. So I wonder if you could speak about how you've managed that. This is not the first time that you're the first. So how you navigate your role as a lawyer, your role as a first, which means that there's pressure to be absolutely perfect, but also that you probably have a need to inspire because you want to make sure that you're not the last. So 2 questions.
So I'll start off with your first one with regards to my experience at the University of Ottawa Legal Clinic. So at that time, it's when I was a law student in French common law, where I volunteered to work in that clinic. So at the time it was to, if I remember correctly, just to assist individuals who were appearing in first appearance court for remand in provincial criminal court. So it was just to help them prepare for that appearance. With regard to my second part of my experience working there, when I was a counsel at Canada Post Corporation, I also worked there at the University of Ottawa, again, legal clinic. I worked there part-time as a file reviewer. So I would go in after hours and on weekends to review all the files of the students to ensure that they were properly filling out the paperwork and to make sure that they were asking the right questions and looking down the right paths to move forward. So that was really my more limited role with regard to the legal aid clinic at the university. With regard to being a first, I have to admit I'm far from perfect. It's not easy always being a first because you're under a microscope at times, but I've learned that how to go about it is just to be hardworking, do the best that I can with my background and my experience, to remain humble, listen well, be collegial with others because at the end of the day, if I do get this nomination, it's working with 8 other individuals on a day in, day out basis. And I think that, as you heard, I'm in it for the long haul. So I definitely want to get along and play well with others. So those are the things that I will do to make sure that hopefully I'm successful in my role there. And how do I manage the pressure? Well, on weekends, I spend time with my family, I paint, and I play with those dogs.
On vous remercie.
We thank you, and we're going to watch you go. Thank you so much.
Merci beaucoup, sénatrice Clement. On revient dans la salle.
Thank you. Come back to the room.
Et Gary Anandsangaree.
Thank you, moderator. I want to begin by thanking the Independent Advisory Board as well as the Minister of Justice and Attorney General, the Honorable David Lametti, for their hard work in getting us here. I also want to thank the many staff that have been involved in this process for the last several months. I'm delighted to join my colleagues here on this historical day, particularly MPs Batiste and Idlout, and I'm honored to share this moment, this very powerful moment with them as we see this historical first. Madam Justice Obontsewen, congratulations on your nominations to the Supreme Court of Canada. I recognize the weight of history that you carry on your shoulders today, being nominated as the first Abenaki member of the Odanak First Nation. More broadly, the first Indigenous person, 89th Justice of the Supreme Court, and only the 11th woman and a linguistic minority from rural Northern Ontario. You bring to this role an exceptional set of credentials and a lived experience like no other. Madam Justice, several years ago you said the following, and I quote, "When I was in high school, I met with my guidance counselor and I told him that I was going to be a lawyer, and he said, 'Well, Michelle, you come from a small French town in Northern Ontario that's likely not to happen. So you should maybe change your career path.' And I had decided, no, this is what I'm going to do. Watch me." So, Madam Justice, to this guidance counselor and to all others, to all others who guide our children, and to our children who may have doubts about their abilities, what do you want to tell them today?
Listen to those that come to you and be supportive, because at the end of the day, all of us as students, we thrive, and all we want is the support of our teachers. And to be mindful, because what teachers say to children and to teens have long-lasting impacts. And, you know, I had difficulties, let's say, with that issue, but I had Ms. Claire Fournier, my teacher in grade 10 and grade 12, who said, you could do it, pursue your dreams, you're going to be a lawyer. And I have to tell you, last Friday, she actually left me a message on my voicemail to congratulate me. So be mindful, your words have impacts on students' lives, and they could be detrimental if they're negative. So always try to be positive.
In terms of the Supreme Court, it's an institution that's deeply rooted in history and albeit colonial history. What will you do to enact changes within the system? And I'm not talking the process, I'm talking about the level of comfort that individual litigants, the access to justice that those from particularly underrepresented groups may have. So what would you do? How would you leave your mark in the Supreme Court that will essentially allow it to be opened up?
First, I'll get there. But I think what's important is to just be myself. I've gone to where I am today by being myself and not changing along the way. And I would expect that if I'm fortunate to be named to the Supreme Court, to continue to act the same way, to be respectful of others, because how do we lead change is by being thoughtful and respectful, and I think that's how we do it.
So on the day that you described the microaggression that you faced, and I'm sure you've faced it many times in your life, when those two lawyers had a conversation and identified you as someone, how do you deal with that personally? Like, how do you overcome it, and how do you keep your professionalism, but at the same time, how do you deal with that on a very personal level so that you're not sidelined by that experience?
Well, I think it's being a judge is you're impartial to the core, and at the end of the day, it's like when we render a decision and we read the newspaper that slams us because we made the wrong decision according to the news. We don't react publicly, and at the end of the day, I think it's just important to remember what our role is and not to deviate from that. Thank you.
Thank you, Mr. Anandsangaree. We're going back online for the next question from MP Karen Vecchio.
Thank you very much. And it is truly an honor to be able to be on this panel and to speak to you today, Madam Justice. I have had the honor to be sitting on the status of women and working with some incredible people across Canada, organizations that are really talking about victims and looking at victims' rights. And we have seen, we had Bill C-28. I know we're not going to talk about legislation, but that had to do with the extreme intoxication. We also saw some really powerful bills go through the House of Commons over the last few sessions, including a discussion on Rona Ambrose bill, which the Liberal government has taken over and did incorporate it into what we're doing for training, and then the domestic violence bill brought forward by Andrew Dillon. I have noted that you have done lots and lots of extracurricular learning, and that is, I'm very, very grateful for that. And as you indicated, that our backgrounds will inform our decisions. Sometimes that is my greatest concern. What do you think you can do within the Supreme Court to make sure that this training continues and that people are there, so we're advocating on behalf of victims?
Well, I could just say for myself is I will continue educating people with regards to our system. And you've heard Justice Wagner is a huge proponent of education and of talking about what the role of the court, the Supreme Court of Canada is. And I would hope with discussion to have discussions with him to continue to fulfill that role, because I'm a huge proponent and supporter of education to the legal profession, not only to judges, but to lawyers and law students also.
I really do appreciate that. We've just finished up some roundtables talking to victims, and I want to ensure that the victim's voice is being heard. Are there any other things that you would recommend that could be done to assist victims when they're going through the Supreme Court system?
Sorry, at the top of my head, I can't think of anything further, no.
No, I do appreciate that. When it comes to judges training, we have seen different things, and perhaps, as you said, you have a background that so many don't have that are sitting there. What else could we do to ensure that judges are willing to take that training?
It's hard to answer that. I think it's just to continue to have the discussions about how things can improve, and sorry, I don't really know what further I could tell you about that.
No, I do appreciate that. As I said, when I'm looking at victims, that is what is coming to the forefront, ensuring that victims are always being heard. So I'm looking at different things. You had talked earlier about being able to, I think it was in your opening statements, when the fact that if you want to be away from your perpetrator, that there is a way of protecting the victims. So I'm looking at things like that and anything that you would think of that could make that better for victims. So when we're talking, I can switch over to the mental health side. When we're looking at mental health, how would you see that court systems? We've talked about the Indigenous courts. Is there something better that we can be doing to ensure that mental health is being taken into consideration when we are going through the court system or sentencing somebody?
I don't think it's necessarily something better, but it's just to be mindful about its existence, and to ask those questions. So I think we have an obligation as judges, especially more though at the trial level, I would probably say, where these files would mostly originate, to ask those questions.
Yeah, absolutely. And just looking at your background, when we're talking about the different things, what type of law did you did some legal counsel, so obviously some corporate law. You did some criminal law. What other kind of law did you practice?
So just to let you know, I didn't do corporate law. So I've...
okay, so I was looking at legal counsel. I'm sorry.
Yes,
yeah, I don't mean to sound that way. Sorry.
Sorry, I have to say I'm a bit of an oddball compared to other Supreme Court people, I would say, because I've always had a career in-house as an in-house counsel. So when I started off at Canada Post, I traveled extensively throughout Canada to do labor and employment files and human rights. I was also responsible to respond to privacy and access to information requests, because when I was there, the minister had responsible for Canada Post, was also responsible, I think, maybe for Public Works or something, I can't recall. So I took care of that. And when I got to the Royal, I was brought in because of my labor experience, because they had 3 unions in Ottawa and 2 in Brockville. And then also, so I continued with the labor employment, then began with the mental health. And I also managed the Access to Information Department at the Royal.
Awesome. Thank you very much, Madam Justice.
Thank you.
Thank you, Ms. Vecchio. So we are going to stay online for this last question online from MP Mike Morris.
Thank you, moderator. I'm joining you today from the traditional territory of the Anishinaabe, Haudenosaunee, and Neutral peoples on Block 2 of the Haldeman Tract. And Madam Justice Obansewin, it is an honor to join in congratulating you on your nomination to the Supreme Court. This is truly and deeply historic. You spoke in your opening remarks about the different paths that folks have come from to the Supreme Court, and I feel like your responses this afternoon, particularly to Senator Pate on the overrepresentation of Indigenous incarcerated women, and MP Idlout on Indigenous languages, demonstrates the importance of someone with your voice and your experience and your path being nominated to the Supreme Court. I wonder if you could share a story or a reflection on what you feel needs to be done to ensure that others more quickly follow in your footsteps?
Boy, that's a big question. I guess it's just, if you're asking what I myself would do, is just to continue talking about my journey and sharing with others. So hopefully that they could see a bit of themselves in my journey and say, hey, I could do that too. So I think it's to continue having discussions and meeting people, and I've never shied away from a good conversation with anyone. And my kids always laugh because when I walk down the streets, I say hello to everyone and I talk to their dogs. And so it's just to continue as I've always been.
Thank you for that. It strikes me when I speak with Indigenous community members here, there are folks who are still uncomfortable self-identifying as Indigenous when applying for housing, for example. And so I contrast that with the significance of the conversation we're in the midst of this afternoon. And it makes me wonder, there's a lot of folks who are watching this afternoon. What might you say to someone like that? What would you offer or reflect back to them as someone in your shoes this afternoon?
I think that what I would say to them is our culture and our heritage nourish us, and it's always a good idea and recommended, I would say, to find out where we're from, because it helps us determine where we're going in the future. So to ask the questions about if there's Indigenous heritage, and to learn to reach out to the community if they're attached to a community, to get involved in the community, to work with elders, because I think that as an Indigenous person, we have just great pride, and it's important, if we can, to all feel that pride as Indigenous people.
Thanks for that. I want to just close by sharing how much I appreciate in your submission how openly you shared about your own childhood. You're talking about not coming from a privileged background, talking about part-time jobs, babysitting in retail, to move to the point you're at this afternoon as a result of the humility you've spoken about, the hard work you've spoken about, and for all of that, I just want to thank you again. Thanks.
Thank you very much.
Thank you, Mr. Morris. As I mentioned, that was the last online question. Now we have the last question here in the room. Last but not least, from MP Yasser Naqvi.
Thank you very much, Dean Rusi. Madam Justice, congratulations. Thank you for sustaining all these questions over last hour and a half, or almost 2 hours. Now, I also have 2 children, so I'm not going to seek your guidance about pets. It's just going to get me into trouble.
Because you're going to finish with chickens and cats.
Yeah,
and dogs.
That's exactly why I'm not going to seek your guidance. We have 1 rabbit and we're having difficulty managing that. But given the historic nomination, your nomination to Supreme Court of Canada, I have been having conversations with my children about that. And my 10-year-old son's reaction has been, "Oh, Canada, it's about time." He seriously said that. And my 6-year-old daughter is just quite excited for the girl judge. Her words, not mine. So I just wanted to share that with you. But in all seriousness, I do want to ask you, in your view, what does your appointment mean for Indigenous peoples and non-Indigenous Canadians moving forward?
Well, I hope it would tell them that anything is possible if you put your mind to it, you work 100%. Sorry, I'm at the risk of repeating what I've said previously, but I hope that it inspires others to believe that you can get there, and to seek out people that could help them along the way, because as I've talked about before, mentorship and even friendships have helped me along the way and made me the person I am today, and made me the lawyer and the judge I am today. So I've been fortunate throughout my life and my career to have those people, and to have a very strong family that supported me and my parents and my grandmother and my husband and my kids. So.
Great, thank you. We've discussed a lot today about obviously Canadian judicial landscape and your role as a lawyer and as a judge, but Canada plays an important role internationally as well when it comes to promoting rule of law, access to justice, independence of judiciary, and Canadian judges play an important role in that regards as well. It's my understanding that you have been involved in training judges, especially women judges in Afghanistan. Can you share that experience with us? What did you learn? How do you see that particular aspect as you become a judge of the Supreme Court of Canada internationally from Canadian perspective?
Well, I've been fortunate along the way because I've sat on, well, as you've seen from my application, I've spoken at a lot of conferences and I've sat on panels with amazing women and men. And when I sit on those panels, I share my knowledge, but I also am lucky to gain knowledge from those that are on the panel with me. But what I love even the most, though, is after the conference is done. I have often had women, lawyers, even students come up and talk to me afterwards and ask me about my journey. And some of them who I had taken under my wing from having met at conferences, and I'm proud to say one of them was named to the federal court in the past couple of months. So I hope that I share with them, and I have to tell you, I've learned a lot from them also. Those who have sat on panels with me, but those that I've met afterwards.
That's pretty remarkable. Once again, congratulations. We look forward to, all of us, look forward to watching your career move forward as an esteemed judge of our Supreme Court, and look forward to reading groundbreaking decisions that will ensure more equality, equity, and breaking down systemic barriers in our country. Merci beaucoup.
Thank you. Merci, Uliuni.
Thank you, Mr. Naqvi. So that concludes the question and answer period. J'aimerais maintenant inviter...
I would like now to invite Madam Justice Obansawin to make a few final remarks.
So I don't see them anymore. Thank you. I'll be brief. Je serai vraiment pas longue.
I'll be brief.
Ki magok nagon sozak adoti melihidit wawadon dam wagan noliuni kawan miziwi awani nodawit. I'm grateful to my ancestors for giving me wisdom today. I thank everyone who took the time to listen to me. Je suis reconnaissant.
I'm grateful to my ancestors for giving me wisdom today, and I thank everyone who took the time to listen to me today. It's been a long session, but I do appreciate the fact that you were here with me, and I appreciate the questions that you put to me. Thank you.
Merci beaucoup, Madame la Juge.
Thank you very much, Madam Justice.
To a close, thank you to all parliamentarians for your participation today. Thank you to all those present in the room for your attention, and thank you to all Canadians watching us or listening to us from coast to coast to coast for your interest in this very important process. It has been an immense pleasure and honor for me to serve as moderator for this occasion. Madame la Juge Obansawin, merci pour...
Madam Justice Obansawin, thank you for your participation today. All our heartfelt congratulations to you, and we wish you the best for the future. Have a nice day, everyone.